So, hi folks, what are the civil procedure rules? Well, basically in the 90s, Lord Justice Wolfe did a consultation on overhauling the civil justice system in England and Wales, and he basically ripped up the old rule book and created a fresh one. The idea was to make the proceedings, the law of procedure governing those proceedings, understandable for people, and also to make costs proportionate. Costs were running out of control previously, and that's actually proportionality of costs, and as well as the way in which the claim is handled is a critical part of those civil procedure rules, and deal with things like disclosure as a classic problem. There was just huge amounts of disclosure and it was sort of unmanaged, and the civil procedure rules attempt to encourage parties to focus only on the key issues and make disclosure of the evidence, which is absolutely fundamental in civil proceedings, much more focused, much more manageable. Now, you may have an opinion about whether or not the civil procedure rules have achieved their objective. There are 90 parts, and there are also an equal number of practice directions. And sometimes I rather think it was a bit of a field day for lawyers, and perhaps we should have gone back to the good old days and keep things relatively simple. Anyway, they're here to stay, so you need to understand them. The first thing to appreciate is you'll probably be representing yourself, bringing or defending a claim if you're watching this vlog, is that as a litigant in person, you don't have any special exemption. Recent high-level judgments have confirmed that only in exceptional circumstances judges will, forgive you for non-compliance with the rules. Okay, it can be something as simple as filing by email when you were told to serve by post or something. So you have got to comply. Now, there are timetables and deadlines, and basically a big part of the civil procedure rules is putting timeframes in place in order that civil procedure moves forward in a proper, managed and proportionate way. So you do have to comply with the time constraints in these civil procedure rules, but it's usually not fatal. Usually if you don't comply or you repeatedly fail to comply, a judge will hit you with costs. He will make you pay your opponent's costs of that period of time that you've wasted as a result of your non-compliance with a particular stage of proceedings. So don't get too panicky, but it could be expensive if you don't follow those civil procedure rules. Okay, now the good news is, I think for litigants in person, the most important thing is simply to read the first section, the overriding objective, and to go through those principles and just use that as a touchstone throughout proceedings. Okay, and it says things like keep costs proportionate, manage things expeditiously. A big part of it is actually in a professional, neutral way, talking to your opponent and making sure they're sent documents that are sent to court, and that you are actually even though you're enemies, that you're actually, where it comes to managing the proceedings, you are cooperating and helping the court to manage the case. So you could do worse than just use the overriding objective as a touchstone for the management of your proceedings. Take for example, you've got a £10,000 claim, and the other side are requiring you, perhaps they're represented by lawyers, to produce documents from a warehouse in Australia that is owned by a distant relative, and they think they're critical to the case. Go to the overriding objective, proportionate to claim value. Is it really proportionate to dig up all these old documents? Probably cost you over £10,000 just to get hold of them. So do you see how the overriding objective could be used in practice? Now, I'm just going to basically tell you what is in the civil procedure rules, the way they're broken down. You've got critically, the key areas are track allocation. Yeah, so civil procedure rules said cases will now be sent down a particular track. There are 3 key tracks: small claims track, fast track, multi-track, 10,000, 10,000, 25,000, 25,000 to 50,000. But I've done other videos on this issue, but don't get seduced into thinking that it's all about the monetary value. It's not. That's just the normal track for cases of that value. Yeah, and don't forget, there's not a special small claims court. Your case is a simple claim, and it takes time before it actually gets allocated to a track. So don't automatically assume that your case is going to be allocated down a specific track. The other thing is practice directions. So a big part of the overhaul of the civil justice system by Lord Justice Wolfe in the 1990s was to create pre-action protocols, and these protocols require you to do certain things before you issue proceedings. Yeah, you have to have exhausted all other options before going to court: mediation, alternative dispute resolution, which is simply setting up a meeting, a neutral meeting with your opponent to try and settle. Whatever it might be, you should have exhausted all other options, you see. Now, there are pre-action protocols which actually, in detail red line what it is that you should be doing in certain types of disputes. Like a construction dispute, you have to do X, Y, Z. So you need to check the pre-action protocols to make sure that your case doesn't fall into one of those categories, and therefore you have to strictly apply those rules before you issue proceedings. However, most cases don't have a practice direction and just simply fall under the general pre-action protocol. Just Google general pre-action protocol, and you'll see, and this, it's useful to know this. I had an opponent on the phone yesterday who was badgering me to talk about settlement and threatening to issue, and I said, well, you can't issue until you've written a letter of claim. It's got to lay out in detail what your bone of contention is, and all we've had from you so far is a short letter. General pre-action protocol states this in some detail, and moreover, you want to settle quickly, well, fine, but we then have between 14 days and 3 months to respond. General pre-action protocol. So you can see how just a little bit of knowledge can go a long way. So yeah, your case will probably fall under the general pre-action protocol. Now, a big part of civil litigation is it's a dogfight. May the best man win, and therefore, in order to sort of put a positive spin on the civil procedure rules, get the jump on your opponent by knowing how to apply them. I'm not saying you need to learn them all, you just simply need to know how to use them. So let's give you an example here. Let's say you've brought a claim and you've got a big defence back, you're worried about it, and you decide you want to throw the towel in. How do you discontinue? Yeah, Google discontinuance civil procedure rules, and then you start to drill into the detail, and you'll see it, and you have to read the sections carefully. You really do have to read the sections carefully. That will say that where you discontinue, the party who's discontinued is liable for the costs of their opponents. So if they're represented by lawyers, that could be quite a lot of money. But let's say your claim is looking like a small claim under £10,000. Go down, Google small claims discontinuance, and you'll discover another little section that says, well, in small claims it's different. In small claims, you don't have to pay your opponent's costs if you throw the towel in. But actually, your claim may not, if you're discontinuing early, have been allocated to track yet. So the takeaway is discontinue only after the claim has been allocated to the small claims track in order to avoid the costs of discontinuance. So you can see how just drilling into the detail of the civil procedural rules can actually find you useful ammunition in order to know best how to run your case. Okay, so main headline point is you do have to comply with these rules. You'll be hit with costs if you don't, but it probably won't be fatal to your case, especially if you're litigant in person. Use the overriding objective as your touchstone. At times you may need to drill into those rules, but hopefully I've illustrated how to drill into them. There's a lot more information about this issue in part 1 of my book, Flying Solo, which has just been released. We've decided we're going to release this book in 8 parts to cover every phase of civil litigation. But part 1 does actually deal with this issue of how to make the civil procedure rules your friend, if you like. Please do subscribe, and you can go onto the Court Wingman website for more general information about how we can help you with your case. Stay tuned, folks. The next topic is going to be how to make the county court system work for you, and I'll go into the challenges that there are, and how best to administer things, and how best to interact with and work with the county courts themselves. Bye for now.